So this shows that this is legislation that is there to make a difference. And we will first have to prioritize what we find most important. The Commission will take time to make sure that compliance is effective.
And welcome again at the CERRE event. Rita Wezenbeek, Director of Platform Policy and Enforcement in DG CNECT of the European Commission. Rita, in your current role, you have the monumental task of overseeing the enforcement of both the DMA, the DSA, and we're looking forward to your keynote speech. Thank you.
So thank you, Bruno, and thank you for the invitation to speak. Good morning to everybody. So my main concern is that my voice lasts, but I will try to to guide you through. I mean, as I was asked a bit, to 1 year of experience in applying the DMA and the DSA. So before doing that, I would also like to thank CERRE for the extensive reports and also for the DMA report that I think is issued today. I mean, it comes at a very timely moment when we are moving from the designation to the compliance phase and the enforcement phase. And as always, it's very good to take a step back and to look at what the experts are saying about what we should do and which are the kinds of assessments and the trade-offs that we need to weigh against each other. So very helpful and very welcome. Now, we are now indeed 1 year down the line, and my directorate has over 100 staff members. We yesterday issued a call for further interest, so we hope to have another 40 to 50 people to add to the directorate. As you know, we are enforcing the DMA together with the colleagues in DG Competition, who have another 40 people. So we are currently reasonably well staffed to face the very challenging task of enforcing the DMA and the DSA. So with this period, 1 year down the line, I would like to discuss a bit with you the state of play on DMA and DSA, maybe around certain cluster topics, and also say where are we now in the compliance and enforcement, and what is the overall picture and the main challenges. So if we move then first to the DMA, now you've probably all followed it, that this started essentially beginning September with the designations of 6 gatekeepers and with the opening of 5 market investigations to assess essentially rebuttals by the gatekeepers. So 6 gatekeepers, 22 core platform services. You have all been able to read the decisions which have been published. The 4 market investigations on the rebuttals are ongoing, and we expect to be able to wrap them up quite soon. There's 1 qualitative investigation into the potential designation of iPad, and that might take a little bit longer. So my experience around this, which was focused in particular around the summer, is that the delineation of core platform services turned out not so much to be a science, but an art. It required enormous discussions, and of course discussions that mattered to gatekeepers and also to us, because if you have a different core platform service, then in particular the cross-use and combined use of data requires the consent of the user. So this means that it really is important for the business models of the gatekeepers, and this also explains why it took a lot of energy and discussion. Now, you've also seen that a number of gatekeepers thought they needed to appeal. Partially, this consideration is potentially behind that. Also, some of the appeals are more about what are the obligations that will be triggered by the designation. So we are working with our legal service to address these appeals. And as you know, there's also 1 injunction request pending. So this is the designations. On the DMA, we're also building the house as is necessary, because we're not in this for the short haul, but for the long haul. So we've published a number of formats and templates that can be used, for instance, with respect to compliance reports, Also various requests, for instance, for the regulatory dialogue, for suspension, for notification of mergers, and also for profiling reports under Article 15. Now, we're setting up the procedures in the House, which is quite a challenging task, also having the registry in place and having the what we call MANPROC, the Manuel de Procédure. We have set up the advisory committee, the high-level group of experts from data protection, competition authorities. Well, I won't mention them all. We find it really important to have strategic high-level advice on the areas that are all interfaces or have interfaces with the DMA. Now, where are we now with compliance and enforcement? So the compliance discussions with the gatekeepers are ongoing in the wake of the compliance as per 7th March 2024. These discussions, as some of you in the room probably know because they participate, are also quite intense. Overall, the gatekeepers take a constructive approach and they are making constructive proposals. We are not satisfied yet across the board. What is very important is that there will be the compliance reports that have to be handed in on the 6th of March. And for us, compliance is not a paper exercise. So it's not like filling out the format of the compliance report and then see what the Commission will do with that in due course. It concerns real work that needs to be done right here and now. And it also includes work with the third parties and the consumers. So for those of you who bothered to look at the template for the compliance report, you will have seen that it has a paragraph that requires information by the gatekeepers and details on any consultation with end users, business users, and interested parties that was carried out in the context of the measures that are proposed, and also how the input of these third parties has been taken into account. So, of course, we are also looking for ways to address that already now, and we know, and you may have seen in the press, that certain workshops are ongoing. Sometimes we will be party to those workshops. Sometimes the gatekeepers will take it on themselves. Sometimes we will have separate meetings with third parties. So we're really making sure that this is not an exercise only between the gatekeepers and the Commission. In order to assess effective implementation, it is very much important to learn from the third parties and also from end users whether the solutions work. So so this means that on many of the issues, it will not be possible to have already a clear-cut view on whether there's full compliance or not immediately on the 7th of March. It will be possible for some issues. For others, it will be possible to say, listen, we agree to disagree, and we then need to take a decision on how we take it further. And for some further effort may be necessary. But as I said, the in view of third parties is very important. So this is where we are now in the compliance discussion. Then over to the Digital Services Act and to tell you the parallel trajectory that we had to the DMA with the DSA. As you know, the DSA introduces rules and measures regarding very important societal topics. So this is about due diligence obligations for the platforms to get their house in order with respect to, for instance, the protection of minors online, tackling unsafe products, but also elements like hate speech, disinformation, and other elements of very maybe lawful but undesirable content. So there are commonalities between DMA and DSA. Both are regulatory single market instruments. There's a common enforcement inspired on Regulation 1. There's also the mutual influence on each other, and there are common themes like data protection, self-preferencing that is addressed in both of the regulations, the importance of recommender feeds, importance of the funding by online advertising. So we in DG CONNECT are in a very privileged position that we can see how the two legislations play out against each other. We can also draw the consequences of what is happening in one field and in another field. And in this sense, I find still a bit disappointing that if I'm in discussions with the gatekeepers or with their lawyers, and I ask questions to the DSA parties of what they're doing on the DMA and vice versa, often the people we get from one and the same company do not know what is happening in the other part of the house. Okay. So designations. Here it happened earlier, April, we designated 17 platforms as very large online platforms supervised by the Commission, 2 very large online search engines. Also, these decisions are published. So the issues were a little bit different than in the DMA. This is not a debate about core platform services. Issues like how do you count users were much more important. Also, who is the provider of the service actually in Europe? Is it the global company or the often Irish company? So we designated in December, as you saw, 3 additional platforms, which are commonly called adult platforms. Also here, it was important to have a procedure to hear the relevant platform on how we went about in calculating users, because this was not based on their own assessment, and we disagreed with what they published. So here also on the very large online platforms, we have appeals by Amazon and Zalando has asked for an injunction procedure that has been partially granted, partially rejected by the president of the court, and the Commission has appealed, so now we're before the High Court to discuss this injunction. Now, one element to highlight on DSA is the key issue of transparency. And so the kicking in of the obligations in August meant that, first of all, there needed to be, for the very large online platforms, the risk assessment. So we now know how the platforms assess their own risks, and they had to also come with mitigation measures for those risks. But at the same time, they had to hand in their content moderation decisions to the database that has been created by the Commission. So for the first time in the world, we have a massive database in Europe where all the content moderations decisions of the platforms are registered. And it's massive indeed. We had to enlarge the capacity of the database because it's already a lot. But if you want, you can check what the platforms are doing and also how it is evolving. Also, they had to publish transparency reports on the kind of decisions they took in content moderation, how many content moderators they employ, how they train their content moderators, and also their terms of reference needed to be very clear, understandable, and there's a different database of the Commission that lists all the terms of reference of the platforms. So the entry into force of the DSA meant a massive increase of transparency on what the platforms are actually doing. Now, this means there is an enormous volume of data available. My colleagues, we are still working also on a dashboard that facilitates the use of this transparency. We also had sessions with journalists, researchers, to help them and to introduce them how to use these databases. And as we speak, there is a hackathon out for the wizards on data to help the Commission and help the researchers develop tools, amongst others based on AI, to make the best use of all these data that now are available. So transparency we see as a very important element for the outside world to control the platforms, and a game-changing element. Here also we are building the house, so we are setting up the cooperation with the member states' DSCs. For those of you who have followed, you may know that on the 17th of February, the DSCs will sort of take up their duties, the digital services coordinators in the member states. They will also be in charge for the smaller platforms that have not been designated as very large. But we also see them a bit as the cavalry who comes in to help the Commission, because we will work a lot together in the assessment of harm in the member states, in the provision of evidence, etc. So we have an information exchange system in place. We have incident management procedures. We also have other regulators, like the media regulators, with whom we have memoranda of understanding in place, also to exchange experience, to collect evidence, etc. Lots of things also going on to further build the house in terms of processes and delegated acts and procedures. Now, where are we there with compliance and enforcement? So, as I said, the 19th platforms handed in their first assessments of the risks. We were a bit overtaken, like the whole world, by the Hamas-Israel crisis in October, which meant that there was a flood of disinformation coming over the world and also coming over Europe. And you may have seen that Commissioner Breton immediately alerted by public letters to the CEOs of the platforms them to their responsibility to manage disinformation. We followed up with requests for information on how they were handling this, and they replied by giving us information on their processes, on their teams, on the measures that they had taken. So also we issued a recommendation to the member states to fast track the implementation that is scheduled for February, but to already have cooperation with the to-be digital services coordinators to tackle in particular this crisis. And we are now meeting with the member states to look at this kind of disinformation. Now we also sent additional requests for information in the framework of elections, for instance, also the protection of children and also online markets. We are working together with the platforms in the context of elections. So teams of us were there in the context of the Slovak elections, the Dutch elections, the Polish elections. We talked with the platforms and with the national authorities to see what needed to be done to prevent the amplification, in particular, of disinformation in the context of elections. So all kinds of enforcement actions with which we wanted to make clear there's a new regulator in town and we are taking our responsibility. So we need to do two things at the same time, which is building the house, making it ready for the long term, at the same time also make clear we are there, we're tackling priorities. And one of the priorities was that we started proceedings against the platform X in December. I think many saw that coming. We are, and I think they also saw it coming. But elements of the proceedings that are now open against X are the quality and solidity of their risk assessment and mitigation measures to counter dissemination of illegal content, also their notice and action mechanisms, also to assess the measures they take to combat information manipulation. And there we look at their famous system of community notes and whether this is effective enough to tackle disinformation. Also measures to increase the transparency. So as of the entry into force in August, it is necessary that researchers have systemic access to public information. But there are issues for many platforms with the APIs or with the costs that researchers incur to have such public information. And then we're looking also at the potentially deceptive design of the blue check system that they use that could be misleading. So this shows the enforcement work is in full force. Now, all of this to show that this is not laag pour laag. We want this information, this legislation to have real effect for European citizens. And I think we can already see the effects. So what are we seeing, for instance, on the DMA? Well, very recently, 13th January and 15th January, Alphabet and Amazon went out to announce that they will let users decide which services they can link or unlink in terms of their data collection. So we will, of course, for all these measures, still assess whether it's sufficient for us. I mean, there are important questions on what are the consent mechanisms, are they sufficiently clear, are they not nudging people to certain effects? You've also seen that Meta has announced that if you do not give your consent, you have to pay. So you have to pay for now, I think it's 9.99 euros per month for a web subscription and 12.99 euros for an additional mobile subscription. We're looking at that together with Meta. So there are separate questions. One is this compliant under the GDPR? Another question is this compliant under the DMA? The dialogue is ongoing and we will have to see what comes. Now we have to, so also on self-preferencing, there have been certain announcements, in particular by Google. Also, choice screens are being tested by the gatekeepers. And Facebook has announced that it wants to move to the interoperability of WhatsApp on the basis of the RCS standard. So even before the entry into force on the compliance date on the 7th of March, and rightly so, the gatekeepers are testing with their own communities and also on a wider scale whether the solutions they are proposing to us are working. We see also for the DSA that the VLOPs have announced a lot of measures. Now, they may have been under your radar because to a certain extent it's changing the terms and conditions. It is also introducing, for instance, an advertising repository where we can all now see who is advertising on their platform for the good and for the bad content. Also for individual content, you can see who's advertising. There's also the compliance functions created. This is all not so revolutionary. But for instance, Meta announced recently that Instagram and Facebook will hide content about suicide, self-harm and eating disorders for children. So that is, of course, also because of the proceedings that are out in the US, but also because of the DSA. Safety and privacy for children. TikTok has announced that accounts of users below 16 years are set to private by default. So also the recommender feed of TikTok can be set on non-profiling. So there are many communications that are already there, changes that have already been made, and of course the DSA is in full force, so they should. DMA also in the wake of the compliance. So this shows that this is legislation that is there to make a difference. And we will first have to prioritize what we find most important, which is, for instance, the proceedings against X, which will also be some elements where we agree to disagree with the gatekeepers under the DMA, but we will address those. And the Commission will take time to make sure that compliance is effective. Now then the challenges. Irene would normally have spoken very much, I think, about the fact that online platform legislation is very hot and many member states want to legislate this. Now this risks that there will be competitive or overlapping or conflicting legislation. So we regard the DSA as complete maximum harmonization in most areas. So that means that there's no place for conflicting or deviating legislation. There has been a recent judgment that said clearly that if you have such type of harmonization, you cannot do that. There's another case where the Advocate General recently concluded there's no room for such legislation. So we're serious about that. Also, I mean, an obvious priority for the coming months will be the protection of elections, of non-biased elections. This is a very difficult task. I mean, it has procedural elements, it has elements of when is there disinformation or not. And in particular in elections, this is a very difficult call to make, but it will be a point of attention. So indeed, the work with third parties on DMA compliance will be a top priority. And also for us, it will be very important to involve the users, the consumers, who have a lot of experience in when does consent work, when do choice screens work, etc. And I'm happy that they're working with us. So many challenges. As I mentioned also, we're not alone in this. We have the member states, national regulatory authorities. We have also the civil society organizations in the DSA to help us, and third parties and consumers. So I would say it's a common challenge for all of us. Let me stop with this.
Thank you. Thank you. Thank you very much, Rita. Thank you very much. I think you for this very, very comprehensive outline of what you're doing, and I think you've laid the basis for going now into more details on the issues you've addressed. I think we'll let some people come in. Sorry? Okay, fine. I'm being instructed that there are questions which can be put, so please come here. You know what I will do? Why don't you stay here? Okay. Okay, a question there. I can see how many seats we have there.
I've been told to stand up. All right.
Okay.
Matthew Newman from MLEX. Good morning. Rita, you just mentioned at the very end of your presentation that the Commission is vigilant about not having overlapping legislation in the member states. And I'm curious if you can go in a little bit more detail about your concerns with proposed legislation in France. This is the digital law that was presented last year by Minister Barrot, and I understand the Commission has sent a letter to France about this, and now the procedure is now been suspended in France. But can you elaborate a little bit on what your concerns were, and if there are any other member states that are acting in other fields that may have conflicting laws with the DSA or even the DMA? Thank you.
Yes, well, basically, Matthew, you said it all. I mean, this is an ongoing dialogue, and indeed there has been a letter. I think the cooperation with France is very productive, and we should not forget, this is always a common element in all these dialogues, that we have the same positive objectives in mind. So it is very important to work with the member states to have common ground. At the same time, this legislation was not agreed for nothing. It was agreed by the 27 member states. It's very important to have this overarching legislation for which the platforms also can rely on the fact that the legislation is the same in all the member states. So we have a very positive dialogue with France and also with other member states that I will not name individually, but it is a point of attention, yeah.